Good morning, Judge Farrell.
Good morning. How's everyone?
Wonderful.
Safely made it here, it looks like. Looks like all the seats are accounted for.
Take a seat and you can start your remarks when you are ready.
All right. I appreciate everybody volunteering their time here today, and I'm going to start off with a little bit of a volunteer story myself. I coached my son's soccer teams for many years, and after doing it a few seasons, I developed a protocol for how I was going to start each season. So what I would do is I'd bring the kids together, we'd introduce ourselves, and then I would tell them, we're going to accomplish 3 things this year. And then I'd have them guess, what are the 3 things? And always one kid would say, well, we're going to win. I say, well, winning's good. That's not one of the 3 things. What are the 3 things? And eventually we would get there. First of those things was we're going to have fun. And my point was, why join a sport if you're not going to have fun? The second thing was we're going to work hard. And my point was, why do anything in life unless you give it great effort? And the third thing was that we were going to play with good character. And my point was that I did not care what the other team did. I didn't care what the other coach did. I don't care what the other parents did. I didn't care what your parents did. That can be a problem. I don't care what the ref did, but we control our own conduct, and we're going to do things the right way. So those were the 3 things. As I thought about this interview, I thought that's been a model for how I've tried to live my life, both as a person and as a professional. Now, first let's talk about having fun as a professional. There's a lot of lawyers in the room. Would you agree that the practice of law is fun? I see a lot of, I'm not so sure I'm willing to go for that, but I do think it's important to recognize, the practice of law is interesting. When we see TV shows and movies that are made about lawyers and judges and court cases, and there's a reason for that. It's interesting, and the practice of law has a great impact on people's lives. I've been very fortunate to have a career where I've been able to do just that. I started off my career at the AG's office doing child support recovery work. And doing that, I had to deal with real, live people who had real, live problems, such as, I'm not sure I can pay my bills if I don't have child support. Or, I'm not sure I can pay my bills if I have to pay child support. I would work with those people to reach a resolution where hopefully they'd be able to move on and both be productive from there. I then moved on to the main AG's office where I had a totally different practice. I represented high-profile clients in high-profile cases. And I had the opportunity to go across the state, litigate many different counties. In federal court, I had the chance to do appeals, both in the Court of Appeals, in the Iowa Supreme Court, and in the Federal Court of Appeals, and even a case in front of the U.S. Supreme Court. It was a very exciting job, and I was very fortunate to be able to do all those things. I moved from there to be an administrative law judge, and as part of that job, it's a huge variety of work. I did complicated cases there in front of the Board of Medicine and the Civil Rights Commission and agencies like that. But a lot of my life was spent dealing with cases from the Department of Human Services, where we had mostly unrepresented people who may not have a lot of education. They're just trying to figure out why the law is having an impact on their life. And I would talk to them, I'd listen to them, and then I'd tell them, this is the law, how it's going to apply to this case, and try to help them understand how a decision was going to come in this case. And that was a very, very gratifying process to be able to do that with regular, everyday Iowans. And then I became a district court judge where I had to do all of the above. And sometimes it seems like even one day I might do all of the above. I might start working on a very detailed summary judgment ruling and then get called down to the family law docket where I'm dealing with 12 hearings involving 12 couples who are not getting along right now. And that's where I would use my experiences to try to help them through that process. So I've had a career that's been incredible. It's been very rewarding. It's been very interesting, and I'm going to say it's even been fun. Point number 2, I have always worked hard. I worked my way through college. I didn't have much help from my parents, not because they didn't want to. They just didn't have any money. I started off the AG's office. It wasn't the most highly regarded job, but I worked hard, I proved myself, and then I was able to move into a position where I could do the kind of complicated litigation that I wanted to do. I moved to become an administrative law judge, and that agency was not well regarded at the time I entered that job. But I worked hard. I wrote literally thousands of decisions while I was there. And then I promoted the division by recruiting good lawyers to become administrative law judges. And then as part of that, I was promoted into management, first as a deputy chief and then as the chief judge. And when I left that division, it was night and day difference from what it was when I stepped in the front door. And then finally, as a district judge, work ethic is still important. I've presided over 89 jury trials. I don't know, maybe some other judge has done that many over the course of the last 9.5 years, but probably not many, if any. And you've seen from my application, I've done my fair share of tough non-jury cases as well. And work ethic is really important, I think, because the Court of Appeals is a busy court. It's not an ivory tower type of a job. You have to get in and you get into a record, you make a decision, and then you move on to the next case, and that's what they do. And I think for my record, it shows that I'll be able to do that. And then the third thing is character. When I was a coach, I coached around 15 seasons. I never got a parent complaint. And I think the reason for that, in part at least, is because my own kids sometimes had to sit on the bench, and my own kids sometimes had to play the back line. And I think parents appreciated that I was trying to be fair to them. And that's something I've strived to do in all aspects of my life, is to treat people with respect, dignity, and fairness. I know as a judge I got to do that in the courtroom, but I've tried to do that in all manners of my life, whether it was as a lawyer, whether it was as a school board member, whether it was a member of the public or whatever it is. That's what I believe we should do, and that's what I would promote as part of the Court of Appeals if selected. Now I want to circle back to one thing before you ask questions. I want to circle back to the kid who said, well, isn't winning something we want to do? It's one of the three things. Because I don't want you to have the wrong impression about me. I really like to win. I'm a very competitive person, and my teams always won. In fact, the last 4 teams, and I didn't keep the stats for this, so but I think I'm accurate. I think the last 4 teams I coached only lost 4 games over the course of 4 seasons, and they won every tournament that they entered. And the reason I make a point of that is this. You don't have to sell your soul to be a winner. You can do things the right way and still be successful. And that's how I've modeled my life. That's what I've tried to do. And that's what I would try to promote and model as part of the Court of Appeals if selected. Questions?
Thank you. I think there's some Big Ten schools that might need your coaching experience. We'll start with questions.
It would pay more than an appellate court judge.
Yes. We'll start questions with Commissioner Hartkoff.
Thank you very much for being here this morning, Judge. You had mentioned that you previously served as an administrative law judge. Can you talk about how that experience would enhance the Court of Appeals?
Yeah, I think so. So, on one, I was writing all the time, so that's important. And I've talked to a couple of people about writing simply in a manner where people can quickly understand it. So when you're writing for people who may not have even a high school education, you're trying to keep things simple. I'm not sure if many of you understand this, but if you go into Word, you can actually run a program that shows you what grade level you're writing for. So I would do that every now and then and see what I was doing. And my goal was to write at a 9th or 10th grade level. And it's not to talk down to people, it's just because if you write at that level, people can quickly understand what you're saying. And that would be true whether I was writing for the medical board, to be honest. So that's some of what I learned as an administrative law judge. But I think more of it is just I had so much contact with regular people about how things were impacting their lives. I probably had, well, I'm sure I had thousands of cases. I would do on average 700, 800 cases a year, and about 350 to 400 would actually be tried, so you can do the math over 10 years. I mean, that's the number of average ordinary Iowans who are in usually a tough position, because that's why they're filing an appeal, of talking to them and helping to, or trying to understand what their circumstances are. And having context is important, and I think particularly for appellate court judges, because you want to understand how your opinions are impacting people at the ground level. And that's true, obviously, we want that to be true for judges and for lawyers who are advising clients, but I think for people too. And I think that experience gives me even a broader base for understanding how decisions impact everyday Iowans.
Commissioner Spies.
Thank you. Good morning, Judge.
Good morning.
I appreciated your mentioning the fun in the practice of law. I have so much fun, it keeps me awake at night. What do you do to strive to improve yourself as a judge?
Well, that's, one thing I do is I talk to my colleagues on a regular basis. And we're fortunate in Polk County, we're right there. I mean, in other counties, sometimes you have to reach out by telephone to talk to people. But all our judges are within the same court complex. And we have a broad range of experience. Like if I have a criminal issue and I want to understand the prosecutor side, I got a couple prosecutors I can go to. I have a couple criminal defense lawyers I can go to, so I can understand both sides from the level of their prior practice. And the same is true with regard to the civil practice. I myself, everybody comes to me with regard to administrative law because that was a focus that I had. And I've done a lot of employment law, so people come to me with those kinds of questions. So those are some of the things I do. But I think you can learn generally from every case. Sometimes I learn from the litigants themselves. I had a criminal defendant the other day who I was talking to. The person was going to be on probation. I said, so what's your plan? And I said, well, I have kind of a plan. And she had 2 or 3 steps that she was going to do. And I said, well, you know what you should do? What I would suggest is that you go back home and you write it out, what your full plan is, and you put it in writing, and you put it in a position where you can actually come back and look at it on a day-to-day basis. She said, oh, that's a really good idea. I said, I didn't just make that up, by the way. I actually got that from a defendant in a prior case, and that's what he had done. And that's part of what had persuaded me to give him probation in that case. So when I see a person in that position, I'm able to use that defendant who gave me that idea and try to spread that to other people. So I think learning can come from any source if you keep your mind open to it.
Thank you.
Commissioner Hanson?
No questions.
Commissioner Stanger?
Thank you. Good morning, Judge. Thank you for your application. Great to see you today. I want to talk a little bit about empathy and respect from the bench. When we spoke, and my colleagues who had tried cases with you, we talked about how you stayed up late at night working through jury instructions even past midnight. And the reason you shared with me is because you had the respect for the jury to get through that. So I wanted you to, I guess, share with the commission about your views on empathy and respect for the litigants and how that would translate to the bench as a Court of Appeals judge.
Well, you mentioned the jury too, and I have a lot of respect for juries. They put a lot of time in the case. They come into the case usually not necessarily wanting to be there, but what I've found is that by the end of the case, they're very happy they did it. And I think one of the reasons, and that might be true with any judge's juries, but I really take a lot of time with the jury. So the deal I make with them is I say, I'm going to give you these admonitions, and I'm going to grind them into you, and I'm going to expect that you're going to follow them. But in return, I'm going to make this case go as quickly as it possibly can. Some judges have rules, they're kind of the rules of the court, it's the 4 or 5 or 6 rules. Judge Stovall, I think, used to have 10 rules, maybe Mr. Parrish will remember that. But I only have one rule, and my rule is don't waste time. So the juries, I think, appreciated that. I keep the case on track and get them out of there as quickly as I can. With regard to the parties, I think it's important to try to make them feel as comfortable as they possibly can. It's an intimidating environment. I've been out here, 34 years. I was intimidated walking into this courtroom to talk to you this morning. So think about being a litigant, walking into a courtroom and being involved in a case that's going to be really important to them. So some of what I do is just try to make them feel comfortable. Maybe during a break, I might even, just talk, with the litigants, get to know them a little bit on the side. So they're starting to feel a little bit of a comfort level. And you get a benefit from that, not just from the fact that they feel a little better about the process, but if they're comfortable, then their testimony goes better. And I think it's just something that we should do. We do have some limits on what we can do. We can't go out to lunch with them or anything like that. But we can make sure they're comfortable in the courtroom and make sure that we recognize that they're people and that I, as a judge, am a person too. So those are some of the things that I try to do.
Thank you.
Commissioner Picklep?
Nothing, thanks.
Commissioner Samarath?
89 jury trials. That's an eye-popping number for me. What will you take from those jury trials if you're on the Court of Appeals? What's going to be the insight that you're able to bring?
Well, I think seeing it at the ground level is really important for the Court of Appeals. You got to have that experience in some way, and it doesn't necessarily have to be a judge. We got a judge in the Court of Appeals, Sharon Greer, who brought that experience probably more than I could. She's tried a zillion cases, and she was an incredible trial lawyer. I was fortunate enough to have her on one of my cases as a judge. So I think understanding all the little things that can happen during the course of a case, maybe why a lawyer doesn't call, a witness, or why certain things happen, and really appreciating that can sometimes be hard to see on appeal. Like I had a criminal case at one point, and the prosecutor's a lights-out prosecutor, and really tough. She gave her opening statement, and it was kind of a relaxed opening statement. I was kind of surprised. And then she put on her top witness, and he didn't give all the evidence that was expected from the minutes of testimony. Well, her primary witness is, a drug dealer, so I mean, it's not surprising that when you have a case involving a drug dealer as a defendant, the other witnesses are either drug users or drug defendants or other criminals. So she didn't get all of that out of that witness as what had been in the court file. So I saw her during a break. I said, well, that witness didn't quite perform as you thought maybe. She goes, well, Judge, that's why I relaxed on my opening statement, because I wasn't sure exactly what he was going to do. And I think those are some things that you won't always see from a transcript. But if you've been there, you can understand why things are. And I think if you've only done appellate law, that can be a risk. I worked with attorneys from the Attorney General's office who had only done criminal appeals, and they could be a little bit judgmental about some of the things that were done at the trial level. And I always cautioned, I said, well, unless you've been there, you might want to be careful about how you're judging people. So I think that's a perspective that I would bring.
Thank you.
Commissioner Roberts?
Judge, you've been on the district court for about 10 years, and before that in ALJ for about 10 years. Can you just do a little bit more of sort of a compare and contrast of those two roles, sort of how they're different and kind of how they're similar?
So, I mean, ultimately you're making a decision, and that part of it's the same. And there are certain things that you're always doing, judging credibility is the same, I think, in both instances. The rules of evidence are relaxed, so that's a little bit different. It's easier to get some things in an administrative context. And all cases are bench trials there. So you don't have any jury trial experience when you're an administrative law judge. Now, you do have some differences on the other side of it, and Ms. Valentine can make you very well of that. But when I would do cases with the Board of Medicine would actually be making the decision in the case. And the administrative law judge is there to conduct the hearing and rule on objections, and then write the decision that the board directs the person to write. So that's a very unusual part of being an administrative law judge. It's kind of like running a jury trial in a way, because you're running it for the board, but they're the one making the decision and telling you how to write it. So that's another contrast to what we do in district court. We never have to do that. I mean, I get to make the decision in the cases that I hear, or I'm letting the jury make the decision in the cases that they hear.
Commissioner Schnur?
I have no questions. Thank you, Judge.
Commissioner Hoytink?
A really interesting case you cited was your racing and gaming case that eventually went to the Supreme Court. Can you just talk a little bit about how working on that case, whether it had any impact on you as an attorney, as a judge, what that experience was like, and kind of a high-profile case?
Yeah, I mean, it was an interesting case. I had it from the very beginning. And I worked with co-counsel Gene Davis, was my co-counsel, who later worked with at the Division of Administrative Hearings as well. But we prevailed at the district court, and we went to the Iowa Supreme Court. And I knew I was a little bit nervous because I had a question from the bench. It was, well, you want to keep talking about these riverboats, but I just want to talk about the horse tracks, and they were the ones being impacted by the tax. And I said, well, this is an equal protection case. We can't talk about one without talking about the other. You got to be comparing the two. And that's where I knew that I might be in a little bit of trouble. And I was right. So we got the decision, and I got a call from a guy who had been the head of the revenue division of the AG's office. He had just retired. He calls me and says, I got to come down there. I got to talk to you right now. So he came down to the office, and he says, you got to take this to the U.S. Supreme Court. They'll take the petition, and you're going to win. I'm not going, okay, whatever. So we eventually did request cert, and sure enough, we got the case. And we quickly briefed it because it was pretty late in the term. And then the case was heard in April, and they decided at 9-0 late in the term. And it was just kind of an amazing whirlwind process, because I really wasn't expecting that would happen. But then we got a chance to see that side of it. We had great support. The National Association of Attorney Generals provided a lot of support for us, a lot of comment. So I got to be a part of that, a part of a national group that was focused on a single case. And then, of course, just being in the courtroom at the U.S. Supreme Court was incredible. I went to arguments all week just to watch them. And then I didn't get a chance to argue it. The Attorney General elected to do that himself, as is his right. But I obviously was there in support of him, and I got a chance to watch that. So it was a once-in-a-lifetime experience for a lawyer. And I think, how has that impacted me from there on? I'm not sure how much I'd say because every case is a case. And I don't walk around saying, well, I'm the greatest lawyer because I got a case of the U.S. Supreme Court. But I do like to mention it because it just doesn't happen very often. Maybe Mr. Parrish can talk to you in conference a little bit more about that because he's been there. What's that?
Leon and I only got a 6-3 vote.
All right, we're out of time, so we appreciate your application and we wish you the best.
All right, thank you very much.
Thank you, Judge.